Welcome to another episode on the Law Rapport. I hope you learned something from this episode. Please like, share, and comment. Now, stay tuned for today's episode. Welcome to episode 74 on the Law Rapport. Today I'm here to discuss the law on anonymous witnesses in the Turks and Caicos Islands. For some brief background, the law was passed in 2020 and can be found in the Vulnerable Witness Ordinance. It starts at section 43. But prior to the passing of the law, there was a case, the matter of Kendall Dean, where a judge in a trial for murder had issued an anonymous witness order permitting a crucial witness to testify in that matter anonymously. The defense counsel, yours truly, submitted very strongly that the judge had no authority to do so. He was overruled. The defendant was convicted at first instance, and upon appeal, several grounds of appeal were taken. The Court of Appeal, inter alia, held that the trial judge had no statutory or common law powers in those circumstances to order the witness to give evidence anonymously. However, by the time of the appeal, the law was already in effect, but it did not affect the appeal. The defendant in that case, conviction, was overturned and he was a free man. But it was not overturned solely on the judge's error regarding anonymous witness. There were a lot of other grounds, identification, etc. Now, before I get into the meat of the discussion, my usual disclaimer: this is not legal advice. It's not intended to be legal advice. For legal advice, please contact an attorney of your choice. Welcome back. The Vulnerable Witness Ordinance does not provide a definition for who is an anonymous witness, but generally an anonymous witness is a witness who gives evidence in secret, or a witness which is granted anonymity in a trial by the court, which means that the identity of the witness is not disclosed to the defendant, the defense, or the general public. Section 43 of the Vulnerable Witness Ordinance grants powers to the court to issue witness anonymity orders. Section 43 says that a witness anonymity order is an order made by the court that requires such specified measures to be taken in relation to witness in criminal proceedings as the court considers appropriate to ensure that the identity of the witness is not disclosed in or in connection with the proceedings. Now, section 43 subsection 2 sets out the kind of measures that may be required to be taken in relation to a witness. These measures includes that the witness name and the details identifying him or her may be withheld. These details may be removed from materials disclosed to any party to the proceedings, that the witness may use a false name, that the witness is not asked questions of any specific description that may lead to the identification of the witness, that the witness is screened, that the witness voice is subject to modulation to a specified extent. Now, in order for an anonymity order or witness anonymity order to be issued, there must be an application made to the court. Usually it is made by the prosecution, but I don't see anything excluding such an application being made by the defense if it becomes necessary. According to section 45 of the ordinance, the court must take into consideration several things before issuing the order. The court may only grant an order if it is satisfied that the conditions set out in section 45 subsection 3A and B are met. A, to protect the safety of the witness or another person, or to prevent any serious damage to property. B, to prevent real harm to the public interest, whether affecting the carrying on of any activities in the public interest or the safety of a person involved in carrying on such activities or otherwise. Subsection 4 states that condition B is that, having regard to all the circumstances, the effect of the proposed order will be consistent with the accused receiving a fair trial. So in granting the order and in taking all the considerations set out by the law, at the forefront of the judge's mind in making the order must be regard to the defendant receiving a fair trial. Section 45 subsection 5 relates to interests of justice considerations. For example, if the witness would not testify without the order is being made, or if there would be real harm to the public interest if the witness were to testify without the proposed order being made. Subsection 6 states, in determining whether the proposed order is necessary for the purpose mentioned in subsection 3A, which is to protect the safety of the witness or another person, or to prevent any serious damage to property, the court must have regard to any reasonable fear on part of the witness that the witness or another person would suffer death or injury, or B, that there would be serious damage to property if the witness is identified. Section 46. What are the relevant considerations that the court must apply when dealing with an application to grant this anonymity order? When deciding whether conditions A to C in section 5 are met, the court must have regard to the following considerations: the general right of the accused in criminal proceedings to know the identity of a witness in the proceedings. So the court must always bear in mind that the accused have a general right to know his accuser, and so no such order should be granted unless it is absolutely necessary for the conditions previously mentioned. B, the extent to which the credibility of the witness is concerned will be relevant to the weight of the evidence when it comes to be assessed. Whether the evidence given by the witness might be the sole or decisive evidence implicating the accused, meaning if that is the most crucial piece of evidence in the matter against the accused given by this witness who is given evidence anonymously, the court must consider if it will be fair in the circumstances to allow this witness to give evidence when there is no other evidence connecting the accused to the crime. D, the court must consider whether the witness's evidence could be properly tested, whether on grounds of credibility or otherwise, without his identity being disclosed. Whether there is any reason to believe that the witness has a tendency to be dishonest, has any motive to be dishonest in the circumstances of the case, having regard in particular to any convictions of the witness and to any relationship between the witness and the accused or any associates of the accused. F, whether it would be reasonably practicable to protect the witness by any means other than by making a witness anonymity order, specifying the measures that are under consideration by the court. So the court must consider if any other measures short of granting anonymity to the witness would suffice. And G, such other matters as the court may consider relevant. So the court in its wisdom could consider other matters that it deems relevant that are not set out in the ordinance. But once the court has gone through the checklist and it finds it necessary to grant such an order, then such an order can be granted and the witness could give evidence without the witness identity being disclosed. Here is where I will leave it for today. Thank you for watching. If you have learned anything useful from this episode, please like, share, and comment, and I will see you in my next episode. Cheers.